Let me begin by saying that today the committee will consider a report recommending that the House cite Harriet Miers and Joshua Bolten for contempt of Congress. It's not a step that, as chairman, I take easily or lightly, but it is one that I believe necessary not only to allow us to gain an accurate picture of the facts surrounding the United States Attorney's controversy, but to protect our constitutional prerogatives as a co-equal branch of government. This is not a partisan concern or a partisan exercise. I could not voice the important principles at stake in this matter better than did the ranking Republican on the Senate Judiciary Committee did yesterday when he asked, "Do you think constitutional government in the United States can survive if the president has the unilateral authority to reject congressional inquiries?"
There's a lot of myth and innuendo surrounding this investigation, but the one thing there is not a lot of is evidence that the White House did anything wrong. Actually, the evidence points the other way. The chair earlier pointed out that he believes we will prevail in this matter. I believe that if we fail, we will be doing a great disservice to this institution, and we will make the presidency in America a much stronger, more imperial office and above the kind of review that I think is appropriate.
The one thing I want to assure you of is a concern that we share, in which you said if we fail to make, if we fail in this challenge for contempt, we could make this a more imperial president. Please, that's the last thing I want to do. Don't let us fail on this morning, Chris.
No. If we fail to make our case in court, if the chairman would yield, our failure is not here. You have the votes here. If we fail in court and the White House ends up with a precedent that is clear that they can withhold evidence from Congress, then we have a problem in the future. That's when we make the presidency imperial.
Well,
I think the gentleman.
Well, you see, the problem is that your appeal for evidence is before the fact. This is what we're trying to do, is get to the evidence. The reason we can't get to the evidence, the White House has, against the rules of Congress, withheld the materials that may or may not prove the case. We can't get Harriet Miers up here, and then we could get to the evidence. Unfortunately, we can't get to the evidence before we get to the witnesses and the documents that we've requested.
On the other hand, I am quite concerned about the fact that if we do bring a case to court, and remember there are jail terms involved for the President's Chief of Staff and the former White House counsel, and lose, then that is going to be viewed as a blank check by the present president and the future president to do whatever they want to effectively stiff the Congress in discharging their oversight responsibilities. That being said, it seems to me then, rather than going through a lengthy review process in committee, bringing this resolution to the floor, and then fighting it out in court and having it delayed forever and ever, the proper thing to do to determine the executive privilege claim, aside from who said what, who refused to submit to what, who didn't show up for a subpoena, is to direct the General Counsel for the Clerk of the House of Representatives to file a civil suit in the United States District Court for the District of Columbia exclusively on the executive privilege claim and ask for expedited consideration of this issue, which I believe the court would grant because it effectively is an attempt to adjudicate a dispute between two separate and co-equal branches of government, the Congress and the White House. This, to me, seems to be the way to go about resolving the executive privilege claim in a manner that is most favorable to the Congress's side of the argument. And I would support such a move to file a lawsuit in the District Court for the District of Columbia because I think there is a bipartisan interest involved in doing this and getting this issue resolved.
And I want Mr. Sensenbrenner to know that we will think very carefully about his suggestion of moving more swiftly if we have to go into court.
Thank you, Mr. Chairman. I just wanted to take a minute to discuss some of the claims that have been made in opposition to the issuance of the report and in support of the amendment. And I think it's important for us to step back for a minute and consider the context of where we are today. It would be one thing if the administration witnesses came before this body and said on a particularized basis that I can't answer this question or I can't submit this document because of a claim of executive privilege backed up by a letter from the President. That would be one thing. It would be yet another thing if the witnesses came into this committee room and said, I refuse to answer any question. I refuse to provide any document with a claim of executive privilege. But it is yet even another thing for the administration to take this position that with respect to a former administration official, I won't even come into the Congress. I won't even show up. I have that much contempt for the institution of Congress, I won't even come. The audacity of that takes your breath away. On the question of whether an administration or former administration official can simply blow off a subpoena and not show up, there is no legal support for that whatsoever. That is beyond the pale. Whatever my friends on the other side of the aisle may think of the claim of privilege generally or the case law in this area, there is not a single case, not a single precedent, not a single legitimate argument in favor of simply not showing up. It would be as if someone who received a subpoena to come into any courtroom in the United States said, I'm not coming, and I'm not even going to dignify this subpoena by coming and explaining why I won't testify. That, to me, is the real gravamen of why we're here. It is not only refusing to come in here and make a claim, but even beyond that, it says that if the Congress finds us in contempt, we will instruct the U.S. Attorney to never go forward. Our word on executive privilege is the only word. It's the first word, the second word, the third word, and the last word. That is the audacious breadth of what is being claimed before us today.